Public session, and I'd like to welcome Mr. Gerry Moriarty of the Irish Association of Pension Funds. I'll invite Mr. Moriarty to make his presentation in a moment, and then we might have a number of questions. Before that, I would like to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter, and that you continue to so do, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person or persons or entity by name or in such a way as to make him, her or it identifiable, and members are reminded of the long-standing parliamentary practice to the effect they should not comment on, criticise or make charges against a person outside the House or an official, either by name or in such a way as to make him or her identifiable. And once again, colleagues, if you have mobile phones, you might switch them off or to flight mode. Mr. Moriarty, you have circulated an opening statement. If you'd like to make that opening statement now, please. Thank you.
First, just welcome the opportunity to attend the committee this morning. The Irish Association of Pension Funds represents pension savers with an aim of ensuring pensions in Ireland are secure, fair and simple. We're a not-for-profit membership organisation. Our members are pension schemes set up by employers for their employees and companies that provide services to those schemes. Services we provide for our members are representation, education and information. In terms of the bill we're looking at today, we have advocated for some form of debt and employer legislation for quite some time. The correspondence on the issue with the Department as far back as 2008. In a joint paper with the Society of Actuaries in Ireland submitted in December 2008, we advocated for some form of debt and employer in order to provide greater security for members of pension schemes, discourage employers from abandoning pension schemes, and to provide greater flexibility in the ongoing funding of schemes. Since 2008, there has been a significant decline in the number of defined benefit schemes and the number of active members, which are employees who are continuing to accrue benefits within those schemes. As a result of funding issues, many schemes have restructured, often reducing members' benefits and also requiring increasing funding from employers. According to the most recent figures from the Pensions Authority, 126 of 611 defined benefit schemes did not meet the minimum funding standard. However, in total, aggregate assets of defined benefit schemes at €64.1 billion were higher than total aggregate liabilities, which are €59 billion. Schemes that do not meet the minimum funding standard are required to put a funding proposal in place which is designed to get the schemes back to meeting the standard. Proposal has to be agreed by the trustees, employer and the actuary to the scheme. If the proposal is for a period longer than 3 years, it also has to be agreed by the regulator, the Pensions Authority. Defined benefit provision is declining worldwide for many reasons, including cost and fluctuation of cost, accounting practices and change in work practices. Ireland is no different in this respect. This has been reflected in the decline in the number of schemes and active members of schemes, with just over 100,000 active members of private sector DB schemes today. A concern often raised with this type of legislation, which imposes a contingent debt on employers, is that it may precipitate the closure of schemes in order to avoid its impact. However, schemes have had plenty of opportunity to close or wind up in recent years, and this legislation has now been under consideration for 2 years with no evidence of that happening. It could be argued that the schemes that now remain therefore are already decided they're in it for the long term. It should also be remembered that the rules of the scheme may give trustees the power to request contributions from the employer in a wind-up situation, which would often bring funding, which may have the opportunity to bring funding above the minimum funding standard level.
Very much for your opening statement, Mr. Moriarty. Deputy O'Dea.
Yeah, thanks to Mr. Moriarty for coming in, and I know that he's time constraints and we won't delay him unduly. Just a few questions I wanted to ask you, if you don't mind, in relation to the documentation we got from the Oireachtas Library Research Group. One of the objections they raised was that if a wind-up which ultimately takes place anyway, is delayed as a result of this legislation. Well, they said a few things about it. You've answered the point, I think, very effectively about people being forced to sort of wind up. I mean, this has been talked about for the last 2 years, and that hasn't been reflected. But one of the things they mentioned is that it might disproportionately affect younger members of the scheme, because the scheme would continue while the wind-up was postponed, obviously, and the retired members would continue to get their entitlements, etc., which might increase the deficit to the ultimate detriment of younger members. That issue was raised, and I'd just like to have your comments on that. The other thing is that the Oireachtas report also states that there might be some constitutional difficulties about the legislation being possibly retrospective, and at the same time they go on to say that it might force people to wind up before the legislation comes into effect. That seems to be contradictory. It also mentions that a law like this might put some employers at a competitive disadvantage, and it might drive some companies into insolvency. And also questions were raised about, I think I might have to modify the section of the bill, the first section there, dealing with appeals, because I don't think I actually got what I wanted to get now that I read the section again. But perhaps you just comment on those issues.
Yeah, sure. On the issue on younger members, I think you would probably need to have a very long delay period, a lot of people retiring in that period to fundamentally alter the structure of the scheme. It may differ from scheme to scheme, but already the provisions in terms of valuing the benefits for members in a wind-up is sort of, as members start to approach retirement, their values get higher than they are further away from retirement. So it's no longer the sort of cliff edge that there was a huge difference in the value of your benefits the day before you retired as the day after. Possibly for some schemes, if you had, a member who's got very large benefits in the scheme and there are only a small number of members, it may make a difference. But overall, I wouldn't see that as a huge issue, unless it's a really long delay where you fundamentally alter the whole structure of the scheme. So I don't see that it could be a really significant issue for the vast majority of schemes. On the constitutional difficulties, the minimum funding standard was introduced by legislation after the Pensions Act came into effect in 1990. There have been lots of changes made to that to enhance member benefits over time, preservation of benefits, where once somebody's been in a scheme for 2 years, they're entitled to the value of keep that as a deferred benefit. Previously, there was the time you could work up to just before you retired, leave the company, and all you were entitled is to get your benefits, your member contributions back. And more recently, there's been introduction of a risk reserve, which has raised the funding requirements as well. None of those issues, as I understand it, caused any constitutional difficulties, so I don't see how something like this could either.
I would imagine what they were thinking about was the fact that we were imposing changes on pension schemes that were in existence, but all those changes affected pension schemes that were already in existence.
Exactly. Yeah. I'm not a lawyer, but when all those other changes took place and there weren't issues, I couldn't see why that was the case. I touched on the sort of forced wind-up before it comes into effect. Like I said, this legislation has been discussed, and there are other similar bills as well for the last 2 years. There's been no experience of a sort of rush to close schemes in that time. I do think that there's been a lot of opportunity for schemes, particularly when there was a lot of funding issues in the middle of an economic crisis. If there was ever a time for a company to wind up a defined benefit scheme, that would have been it. I think there is still a lot of employer goodwill towards defined benefit schemes, and a lot of the restructuring that has been done in conjunction with trade unions as well. So people have worked out and sat down together and got solutions. So again, if that was going to happen, we'd have been seeing evidence of that over the last 2 years, and there's certainly been none of that. The issue about putting employers at a competitive disadvantage, I think the way employers have to account for defined benefit schemes within their balance sheets, they already have to do that. So I'm not sure that putting a contingent debt on the employer from a balance sheet perspective for most employers is going to make any significant difference. It's already there, it's already accounted for in their books. So again, I don't see that as a huge problem. And again, because this is a contingent liability, it's only if the employer is trying to wind up a scheme that's not fully funded, it only comes into effect when that's triggered. So again, from an accounting perspective, it's not a real debt, and it's already in the balance sheet in some form from an accounting perspective anyway. So.
Right. Can I just ask you there, I don't intend to introduce legislation that's ultimately going to drive some companies into insolvency. I realise that I might have to refine, that section of the bill, because, insolvency or a solvent company can be a company with a very slight excess of assets over liabilities and a pension deficit of $1 billion or something like that, it can range from a very, very profitable company with a very small deficit. So, I've tried to mitigate that by, giving the Pensions Authority the right to say, look, you can pay a lesser sum up to 50%, or you can pay it over a 5-year period with an appeal to the High Court. But that might need to be modified further, because we wouldn't like any. Would you agree with that? We don't want to, as I say, we don't want to drive companies into insolvency forcibly. That's the last thing we want to do.
Yeah, no, absolutely. And I think if there are any kind of specific circumstances where that might be the case, or there's potential for that, I would certainly agree that should be looked at.
The section, yeah.
Yeah, because I don't think any employees are going to welcome a situation where they've got a better pension, but as a result they've lost their job. So,
yeah, and finally, on the minimum funding standard, what would you would agree with our approach on that, to ask the Pensions Board, or should we be asking somebody else to examine this thorny question other than the Pensions Board?
I would certainly agree that it should be examined. I think the minimum funding standard it looks at a kind of snapshot picture in time, and it looks at what would happen if a scheme were to wind up at that time. But many companies and schemes will argue, we're in a good position, we've no reason why we should wind up at this particular point in time. And while we might have an issue in terms of if we had to, we couldn't pay all the benefits. But if we look out over the next 40 years when we're planning to pay benefits, we're perfectly fine from a cash flow perspective. I can also understand from a regulatory perspective where you don't have the sort of protection of, forcing the employer to bring it up to full funding, or you don't have a pension protection fund that would cover an insolvent employer situation, why the regulator would be focused on, okay, you may not wind up, but we have to protect against that worst case scenario, because there aren't the other triggers and protections in place at the moment. But certainly, if this type of legislation came into effect, where there was that additional protection, I think that gives a very good opportunity to then re-examine the funding standard as it works.
And what do you think of the system, the pension protection scheme? Do you think, I know there's a pension protection scheme in the UK, but you're dealing with a totally different scenario there, vastly bigger market. Do you think there's any scope for anything similar here?
I think it would be difficult. I think just because of the small size of the market. And the danger is, because the market's very skewed as well, we've got a very small number of very large DB schemes who would probably in effect just be paying for everybody else in a sort of insurance scheme. It certainly merits it being looked at. I know it's been looked at before, but there's a lot more evidence around how the protection fund works in the UK, and maybe that could be brought into.
Okay. I got correspondence actually this morning from somebody with an interest in this subject, asking me about the IORP2, which we've already had discussions with the Minister about, and which there seems to be some conflict about. Judging by the representations we're all getting on all sides of the political divide, has your organisation any position on that, or have you any views on that?
Not particularly. I think the particular issues are for very small sort of self-directed schemes, which are mostly for company directors. Our members tend to be more on the large employer schemes. We do feel that while the government's been clear that currently the current IORP directive only applies to schemes of more than 100 members. The intention is to apply it to all schemes. We certainly feel that shouldn't happen, at least until there are suitable alternatives for those smaller schemes. The regulator has been very clear that they want greater consolidation of schemes, that we have too many small schemes, and I think this is a trigger to make that happen. If you make the governance requirements so difficult that it forces schemes to do something else. But at the moment, those other options that are available are planned to be changed in terms of the regulator has said they want a new regime for regulating and authorising master trusts, which are multi-employer schemes. So you've got one scheme with lots of different employers in it. But those provisions aren't in place yet. And we also know there are plans to introduce auto-enrolment, where all employers are going to have to put their employees into a pension scheme. And our concern is that if you, without either of those two being on the table yet, if you force a lot of additional requirements on smaller schemes, employers are just going to stop doing anything. And we feel that would be a mistake. Until that's in place, we feel the derogation should continue to smaller schemes.
That's fair enough. Do you want to?
Just very briefly, Mr. Moriarty, you indicated in your opening statement that only about 20% of DB schemes actually meet the minimum funding requirement. I suppose to regularise that and to increase that percentage, is there a significant cost involved?
Yes, I mean, there can be. I mean, all of those schemes will be on funding proposals, and because of the aggregate figures I gave, where actually there are more assets than liabilities for the system as a whole, I think it's probably fair to say most of those schemes that don't currently meet the standard are probably pretty close to getting there. A lot of them would have put in probably 10-year funding plans 8-9 years ago, so they're probably coming towards the end of that. A lot of the schemes would have, in that effort to get back to full funding, would have probably done a combination of things. One would be reducing some of the benefits within the scheme. Quite often what schemes would do is maybe take out any future promised increases or change retirement ages, which increases the overall funding position. But it will also involve additional contributions from employers and quite often from employees as well. So yeah, there would be a lot of pain in terms of getting back to that full funding position.
Okay. And I suppose it's that pain I want to ask you about. It's a global, I take it it's a global figure, but for companies who are in a position where they may have to get back to a particular level, where there is employer input, is there I suppose, a risk that would make that company less competitive in the marketplace for whatever activity they're involved in? And do we have any figures to underpin that? Because 80% of the, while you clearly said, Mr. Moriarty, that many of these companies may be near the, I suppose the question is how near. Do we have the statistical data of the range of companies? Of course.
Yeah, basically it's 20%. It's only 20% of companies that haven't reached, that aren't at the minimum funding standard.
Yeah,
so 80% are. Yeah. The figure, actually, the lady who emailed me this morning gave me a figure for the deficit, for the total deficit for 126 companies that haven't reached. It's 1.8 billion. Is the figure 1.8 billion? That means that the other companies, the 80%, must be 1.8 plus the difference here, which is 5.1. Yeah.
I appreciate that, and I suppose my specific question was on and I acknowledge what you're saying in terms of the global figures. I suppose my concern is, and I know you would be the same, Deputy O'Dea, that if you're introducing a mechanism to ensure that there aren't unintended consequences where a particular company may lose competitive advantage in trying to meet this because of employer contributions.
Yeah, I mean, companies will obviously always argue that they can do better things with their capital and spend it on the company. But I guess that is one of the things when you have a defined benefit scheme in place that you almost sign up for, is that there is going to be this fluctuation in costs. For companies that go the other side and go back into surplus, the contributions will start to reduce over time. But certainly, yeah, companies are probably spending more than they would have planned to. But the whole idea of that restructuring plan, the funding plan that gets put in place, is that it is signed off and agreed on between the company, the trustees and the regulator if it's longer than 3 years as well. So there is quite a bit of sort of toing and froing in negotiation that goes on, so that everybody can come out with a figure that they're comfortable with and that they can live within, because, you know, companies have to look at what they can afford, and then what they want to pay as well, and try and get the right balance between that.
Sticking with you, Mr. Moriarty, I'd conclude on this point. It's not just what they can afford. I suppose the point I'd make is the cost base of a company trading and their competitiveness to that company who have a DB scheme versus a company where they're trading against another company who doesn't have that scheme. Full stop. I make that point.
Yeah, no, absolutely. And I guess for some companies, you know, those companies would have had the opportunity to close the schemes down. A lot of them feel strongly that as part of the overall benefit structure they offer to employees, they feel it's important enough to continue to offer that. So, but I take the point absolutely. I'm sure there are lots of other things I would prefer to be spending the money on in making the company more competitive.
You understand this is a private member's bill. I suppose I want to ask you one general question. Are there any elements of the bill that cause you any concern?
I wouldn't say concern. I think there's probably some maybe technical issues around some of the wording in it. For example, it talks about if a company decides to wind up a plan, technically it's the trustees who have to wind up a plan. Generally, if the company tells the trustees they're going to stop paying contributions, the trustees are sort of forced into wind up at that stage. But I'm guessing those technical issues should be can be picked up on. The piece about if categories of members feel they're being treated inequitably, I'm not sure about that in some ways, because
what I was trying to get at there is not so much a winding up situation, because there's a legislative provision for wind up. It's on a restructuring. It's on a restructuring, and it's in response to a lot of representations we've had from pensioners, company pensioners, that they have no input. They're simply communicated with. They have no part of negotiations. They have no input, and they just are communicated with to say that as part of this restructuring, we're going to unilaterally reduce your pensions or refuse to pay you cost of living increases or whatever. And they simply want an input into that. And that's what I was trying to do there.
Okay, yeah, that helps in terms of context, and I understand, because I hear a lot of those arguments as well, and I guess pensioners feel a bit left out because trade unions negotiation part of current employees, and actually deferred pensioners, people who've left the company, probably don't get a lot of say as well, other than they are communicated with. They do have the right to respond to that communication, but then things can move on. And I'm guessing it's more probably questions from the Pensions Authority as to, you know, what they can actually do and, you know, what the output of that would be. But I better understand the context of that now. Yeah,
but just to add to what the Chairman is asking there, would it have been better, I wonder, if we put in for an appeal to the Pensions Ombudsman rather than the Pensions Authority?
I think it probably comes more within the remit of the Pensions Authority, because they are the party who sign off on those restructuring proposals as part of the as those plans. So, whereas the Ombudsman is more specific if there's been malpractice.
Services, okay, that's grand. That's fine.
Any further questions?
No, that's very, very clear now, and thank you very much indeed for your response.
Have you any concluding? Okay.
If you have any further comments or observations before we move on to further stages of the bill, feel free to send them on to me.
Absolutely.
I was going to make that point specifically. You referred to, I suppose, a number of what might subsequently become technical amendments.
Sure.
If you have any of those either directly to the Deputy or to the Committee, they'd be very useful.
Okay,
we would appreciate that. Mr. Moriarty, thank you very much for your attendance today. It's been very helpful. And we'll adjourn for a few moments till we have our next witnesses. Thank you. Now in public session, I'd like to welcome Dr. Laura Bambrick and Mr. Billy Hannigan. You're both very welcome. Before I ask you to make the opening statements, and then we'll have a number of questions. We have received your opening statement, but I'll allow you to make it, and then we'll take a number of questions. Before that, I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you're directed by the committee to cease giving evidence in relation to a particular matter, and you continue to so do, you're entitled thereafter only to a qualified privilege in respect of your evidence. You're directed that only evidence connected with the subject matter of these proceedings is to be given, and you're asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person, persons or entity by name or in such a way as to make him, her or it identifiable. And members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the Houses or an official, either by name or in such a way as to make him or her identifiable. So, is it, Dr. Bambrick, are you doing the opening statement?
Right.
Yeah. Okay, please.
Thank you. So, thank you, Chair, Deputy, Senator. On behalf of the Irish Congress of Trade Unions, I would like to thank the members of the committee for the invitation to input into the pre-committee stage scrutiny of Pensions Amendment No. 2 Bill 2017 and to outline the views of Congress on the regulation of the defined benefit model of pension provision. I'm accompanied by Billy Hannigan, National Secretary at Forsa. Congress is the largest civil society organisation on the island of Ireland, representing some 700,000 plus workers across the economy. Congress has been to the fore in highlighting the serious need for radical reform in the area of second-tier pension provision, not least because less than half of all workers have an occupational or private pension to supplement their state pension. 90% of public sector workers do, compared to 1 in 3 workers in the private sector. As the state pension is paid at a flat rate rather than earnings related, workers without a supplementary pension are exposed to a significant drop in their living standards in old age. Congress represents the great majority of members of defined benefit schemes. Most DB schemes were first established in the collective bargaining process, with trade unions and employers agreeing the terms, rules and benefits of a scheme. With pension assets plummeting due to the international financial crisis, many DB schemes, already under pressure, fell further into deficit from 2008. Today, over 90% of DB plans are closed to new entrants. However, while in decline, approximately 102,000 pensioners, 111,000 active members and 415,000 deferred members draw or will draw retirement income from DB pension schemes. As such, the DB sector, with assets under management of over 62 billion, remains a very important part of pension provision. Congress has played a leading role in attempts to rescue the DB system from the sustainability challenges it faces. We have done this in 2 ways. Firstly, by negotiating the restructuring of individual schemes, and secondly, by engaging with government to strengthen regulation and oversight so that there is greater protection for workers who are members of private pension schemes. Indeed, we had several meetings with the Taoiseach, then as Minister for Social Protection, Leo Varadkar, and we had a general understanding that he was well disposed to legal protection to limit, where possible, DB scheme closures. The publication of the Heads of the Social Welfare, Pensions and Civil Registration Bill 2017 confirmed this in requiring employers where a scheme is in deficit to submit a funding proposal within 6 months of the date of the actuarial funding certificate. Obliging employers sponsoring DB schemes, whether in deficit or not, to give 12 months' notice of their intention to cease contributions. Enabling the Pension Authority to determine a schedule of contributions that will restore the DB schemes which do not meet the funding standard reserve to solvency in circumstances where the employer has failed to engage with the trustees to develop an agreed funding proposal. However, government has failed to date to legislate these measures. In February last year, government published an ambitious 5-year plan for pension reform, covering the entire pension landscape. One of the roadmap's 6 strands focuses exclusively on improving protection for DB pension schemes in the form of more effective regulation, oversight and transparency. Disappointingly, the actions and commitment deadlines set out in the roadmap have been missed. Congress therefore welcomed the committee's scrutiny of Deputy O'Dea's bill and the issues it highlights. In short, as the committee will be aware, this bill aims to protect DB scheme members against the risk of employers winding up the scheme. It proposes to provide an appeal mechanism for members where a scheme is being wound up by trustees and to make it illegal for a solvent company to wind up a scheme in deficit without consent. The bill also proposes to give new powers to the Pension Authority. This bill, together with the roadmap, makes clear that there is political consensus that stronger regulation is required to support DB pension schemes and to protect the interests of members of these schemes. A key weakness with the current regulatory regime is that there are no safeguards to prevent an employer unilaterally deciding to cease paying contributions to a scheme or otherwise trigger the wind-up of the scheme. The consequential unfairness of this has been crystallised in a number of high-profile cases where financially secure employers announce their intention to withdraw their support for a DB pension, putting the pension benefits of members in jeopardy. Congress is aware of some employers' concern that a rebalancing of the regulation of DB schemes will result in a degradation in the financial standing of firms operating such schemes. We do not accept that this is an inevitable consequence. The purpose of what government had proposed and what is proposed in this bill is to ensure that employers are required to enter into discussions with trustees to address funding issues where they arise. It is the view of Congress that this is entirely reasonable. In closing, Congress sees the scrutiny of this bill as an opportunity to deliver on the political consensus that stronger regulation of DB pension schemes is required, so that hundreds of thousands of active, deferred and retired members of DB schemes can rest assured that their interests are protected and that they will get to enjoy the benefits they have accrued over their working lives. Thank you for your attention, and we are happy to take questions.
Thank you very much, Dr. Bambrick, for your opening statement. The way I'm going to deal with this is I'll let each colleague ask a number of questions, and either of you feel free to, it's not an either or. And to my colleagues who are answering questions, I would just remind you, this isn't a general chat about pensions. It is specifically scrutiny on the provisions in Deputy O'Dea's bill, and I'd ask that those questions be formulated in that regard. Deputy O'Dea.
Yeah, thanks, thanks very much, Director, for coming in, and thank you for your presentation, which we appreciate. Just a few questions there. You mentioned the government's proposals, which, as you rightly say, haven't been legislated for yet. I was studying an outline of those proposals, and I understand, you know, that they don't really significantly add very much to the protections that are there already. There's a lot of talk and a lot of proposals for extra consultation, but there's no compulsion. So I think what we're proposing is something stronger. You know, that there actually is compulsion, and that there's that the unpaid amount of the deficit will be a debt on the company, etc. Now, just a couple of questions. In relation to the first section there, I think my original intention in drafting that section was to provide for a situation, not so much of a wind-up where there's a statutory provision for how assets are distributed in a wind-up, but for a reorganisation where there's a certain amount of discretion as regards, you know, how a reorganisation is handled when benefits, we say, are reduced across the board. I've had a lot of representations that pensioners have no say in that, even though they could be one of the parties adversely affected, indeed they often are. So I just wanted to ensure that provided there was a majority of the overall membership in favour of looking at what was proposed by the trustees by way of reduction of benefits in a reorganisation, that there be some appeal mechanism which includes pensioners. I probably haven't taken the most elegant route to get into that conclusion, but we can redraft it. One of the things that has been mentioned in the department analysis is that that something along the lines of what we are proposing would be a disadvantage to younger members, because in the case of an inevitable a scheme which is closed down eventually, that if it's delayed, if the closure is delayed, the present beneficiaries can continue to receive their benefits to the debt, and thereby increase the overall deficit, and this would adversely affect younger members. The other thing they mention is that you know, we want to guard against the protection of driving companies into insolvency. I've tried to do that to the best of my limited ability. I've been, you know, allowing for a lesser payment, but not less than 50%, or payable over a 5-year period, which ultimately an appeal to the High Court. Perhaps we could be more flexible there, you know, because solvency, you know, can range from a situation where the assets barely exceed the liabilities to very, very wealthy companies, and a pension deficit can be anything from, you know, 50,000 to $1 billion or $2 billion. So, you know, we have to get that balance right. The other thing I think that was mentioned was that that it puts companies, a proposal like this would put companies at a competitive disadvantage. So they seem to be the main issues that have been raised So I'd appreciate, your comments on those. Either way.
I'll take the first point. I suppose the first point we would see about the competitive disadvantage is that with the movement towards auto-enrolment, another concern that was raised was that such legislation would encourage companies to close down their pension scheme before this legislation or similar legislation was enacted. But since the 2000s, since this legislation was last in the House, and indeed the 2017 social welfare bill coming from government, we have seen and we are seeing movement towards auto-enrolment, albeit other milestones are being missed there. But I think members will agree there is a momentum towards auto-enrolment which didn't exist in 2017 when this legislation and the other legislation was put forward. So while auto-enrolment won't remove the incentive and the unfair competition, it will seriously reduce it. DB pension contributions being much higher than what is likely to be required by auto-enrolment. So one of the big pieces we've seen was, because there's no legal obligation currently for companies to provide a pension, that in time, in hopefully in near time, is going to be addressed. So we would see that the competitive disadvantage, we would see auto-enrolment as evening the playing field, because most employers that have a DB schemes, we would see them as good employers, and our concern, we would share the concern that nothing is done to put those jobs at risk. So while we are eager to have this protection for members of DB schemes, we do also want to protect the viability of those jobs. So we are not requesting anything that we would feel would put that in jeopardy. For your other points, I'll refer to Willie.
Well, I think it's really just a general observation in terms of the original government proposals which were published and then weren't proceeded with. And I think my colleague, in referencing them, was simply saying that there appears to be a degree of consensus that something needs to be done, and that employers must have some obligations to simply not be in a position to simply shut down schemes. Now, the precise terms by which that's done, I'd say we're probably okay, there might be a degree of divergence between the terms of the current bill and the original intentions behind the original government proposals. But I mean, if one reads simply the roadmap for pensions reform, it's an absolute clear statement by government that something needs to be done. And that's, I think, the reference that Laura was making in her contribution. Like, to be quite frank, whether it's done by means of this bill or by an amendment by this bill or by a combination of the two efforts, it is that something needs to be done.
Sorry, what about the point about younger members? Sorry. Yeah. Just the point about younger members being disadvantaged by delaying a wind-up that ultimately takes place.
Well, ultimately, I mean, in any circumstances where changes to benefit structures are being put in place, you actually, I mean, I acknowledge you do end up with the potential of a conflict between the interests of the pensioner, the person who's coming close to pension age and sees, well, I'll be fine, and the younger member. I mean, there isn't a Harry Potter solution to that, unfortunately, I think, to be quite honest. And there is a potential for conflict, to be quite honest, in terms of trying to protect somebody's benefit, which is going to become payable perhaps in 30 years' time, and Billy's benefit that might be going to become payable in 6 years' time.
Yeah, point taken.
Senator Higgins.
Yes, thank you very much. And maybe just to pick up on that last point, though, I do think it sometimes gets thrown in, and I think there can sometimes be a touch of disingenuity of trying to put the participants in the scheme effectively against each other. I think that it certainly is if I was and I have been a younger contributor to schemes that I then left before I would have benefited from in that context as well. I think for many younger employers, younger employees, the level of trust are the idea that you can have a relationship of trust with your pension scheme, and trust with your employer is very, very important. And I think that many will look and see if their older colleagues are being treated poorly or having their schemes pulled away. I think it will make many younger employees question the trust and relationship they would have. So I think there's an element of trust in pension schemes and defined benefit schemes, and especially trust in the idea of employees of one company engaging collectively with the scheme, which is probably equally as important in that regard. I just wanted to pick up just a few different pieces. I think, I mean, this is an issue. It has been, it's funny when we mentioned the idea of that, you know, the danger of people closing schemes because legislation is coming. So I remember myself, I put proposals, I think it was in 2016, at report stage of the social welfare bill at the time, you know, in report stage in the Seanad. So of course, if it had passed, it could have been law within 10 days. You know, and there is an element of, you know, there was a moment, there have been different times, and certainly I think it's really unfortunate. I know this committee expedited looking at this issue back in 2017. You know, we had we did a very, very expeditious legal review of that area with the hope that it could have been brought in over summer 2017 and brought forward. And again, you know, it's unfortunate that there's been a 2-year head start on this area. But maybe just a few practical things I wanted to ask about. One is, in regards to the bill, there's a number of time periods being talked about, and I think maybe Deputy O'Dea, I noticed the period at the 5 years, and that's one that you're looking at and considering, but I think that idea of there being time periods, and I like in a way, and perhaps you might comment on the idea that the bill doesn't simply take a snapshot of the finances of a company, but it says, well, we're not simply looking at the snapshot of the company right now, but we're looking at, is there a capacity over the next 5 years, for example, for that company to restore itself, so that you don't have the danger of, say, a moment of an outlier moment of artificial depression in company finances being perhaps used to justify the unfeasibility of a scheme, but that there's a longer period of time under examination. And I think that's something, maybe you might comment on how that could be used effectively. And there may be scope in terms of the appeal of members. Perhaps that's an area that might also need a time period, because we want to make sure that that isn't just a technical opportunity for appeal, you know, over a bank holiday weekend or something, but that there's, which unfortunately we have seen those kind of circumstances of very short notice periods, but that there's a reasonable period of notice on that. Just, it was mentioned in respect, maybe you had mentioned the auto-enrolment schemes, and if you see potentially that within this bill or maybe in complementary legislation around situations where companies may wish to be moving from a defined benefit scheme to an auto-enrolment scheme. If you know what I mean, situations where companies are bringing in auto-enrolment scheme for maybe their new or current or young employees, but have a defined benefit scheme, you know, develop what you think kind of good practice, potentially, and good legislative practice might look like around that transition. So, for example, if I've been working for 5 years or 10 years and I've only a certain number of defined benefit contributions that I've made, the scheme is winding up, but you know, do I carry that benefit? You know, how does that work? And you know, if you have thoughts on what you think good practice might look, I mean, are they going to simply run parallel within companies, or is there scope for the winding up of one to somehow segue into the other? And that would be maybe a situation that wasn't insolvency, but was around transition. If you just had thoughts on that. And then lastly, in terms of the roadmap for pensions has been mentioned a number of times. And without wanting to stray too far, as with due respect to the chair, but it is in terms of the roadmap for pensions. What we're discussing here is people who have in good faith paid in over their lifetimes and expected and planned for a certain level of existence, a level of security in their retirement. But similarly, in relation to the roadmap for pensions, there are issues at the moment around the contributory pension, which again people have planned for, contributed to, paid into, and while the transition from 20 years to 30 years had perhaps a 10-year signalling time, the discussion that has been there in terms of some of the debate around the move to 40 years contributions versus 30 years contributions in terms of qualification for the state pension, and perhaps any parallels you might see for those who have planned and contributed over their working life, suddenly finding the goalposts moving in that regard. Thank you.
Thanks.
Dr. Bambrick or Mr.
I'll start off with that. I suppose starting with the last and working backwards. So you mentioned there about the total contributions, the moving from the yearly averaging to the total contributions method. And while we did think originally, the original proposal was that 30 qualifying years would be required, and now we're looking at 40. And total contributions, I'll remind members, is due to come into effect of January, so we're talking 8 months' time. So we've seen very little progress in that. If that's going to be the new movement, people will have to know. In fact, we're already receiving messages directly into Congress from people who are nearing retirement and want to know what they will require, what number of years. But we think in relation to this with DB pensions, the real difficulty is in the move to the qualifying age with the pension, where we're seeing people now in 2021, in 18 months' time, will have to wait till they're 67 to qualify for the pension. Now, arguably, anybody who has a DB pension and is nearing retirement, they will be able to start drawing that down from 65, if not earlier. So DB pensioners are possibly in the best of the worst case scenario, in that they will have their DB pension to bridge the time between the state pension coming into effect. We would argue that it's the qualifying age is causing the most difficulty for people rather than the qualifying age. People have now had to bridge an extra year where they mightn't have a supplementary pension to help them. Now it's going to be, or in 18 months' time, it's going to be 2 years. With the total contributions approach, we're very surprised we haven't had clarity to date on that, so we would be expecting clarity very soon.
And just on that regard, because I think it won't be clarity, I think what the Minister has told us is that it is a discussion and a debate. Just if you could clarify around the position of ICTU around that number of contributions issue, and also around the issue of having at least, for example, a 10-year lead-in time if you're going to increase a 10-year requirement. Could you perhaps just on that 30 to 40 before we go back to
Yeah. So Congress's position is that it should be 30 years, and the reason why, there are many reasons why, but one is a practicality reason. Social insurance coverage only is very late coming to Ireland because we didn't industrialise until the 70s. So while we had the requirement to pay social insurance from the mid-60s, very few people in Ireland were working in insurable employment. So pensioners that are coming, or people that are coming into pension age, will find it very difficult to have 40 years contributions. If you were working as self-employed, you didn't need to pay a contribution up until 1991. So if you're due to retire this year, or next year, it is an impracticality for you to have 40. If you were working part-time, you only had to pay a social insurance contribution from 1988. Some civil servants haven't been required to pay the full social insurance. So we can't introduce 40 years when people didn't, even though they would have been in full-time or part-time employment, they weren't required by the law of the land at the time to make a social insurance contribution. So 40 years is just not practical. So there are other reasons about, as you said, not giving people enough of a lead-in time, but that for us is the ultimate reason. It's just too difficult for people to reach that goal. It's unrealistic. It's going to be, we've seen with the difficulties the 2012 pensioners had, it'll be small fry if we introduce a 40-year target in January of this year. I suppose, so we would say that the qualifying age will be the bigger problem for people as that's being pushed out. With auto-enrolment, we did, when we were making our submission to government on auto-enrolment, it was a concern and is a concern of Congress that auto-enrolment will cause displacement with current occupational pensions. Now, for some pensions where the contribution is less than the 6% employer contribution, that will be fine. It'll bring people up. Our fear would be that the recommended contribution would become a ceiling and not a floor, that employers would reduce their contribution down to the proposed 6%, if that's what it's going to be. So, auto-enrolment would displace pensions, existing pensions, by employers moving over or reducing the level of contribution if it's above the minimum. Another way we see a possible fear for auto-enrolment displacing current good occupational pensions is that it will be closed off to new members, and new members will be auto-enrolled into the state, and existing workers would remain in the occupational scheme. In our submission to government for auto-enrolment, we ask that this area will be examined within the first year and time after that to see if there's a displacement, and if there is, that we will look towards good practice that the Senator mentioned there. You mentioned timelines. We think it's really good, regardless of what the timelines will be, that timelines are introduced, because the current legislation as it exists is an employer can wake up this morning and decide that they no longer want to contribute to a DB scheme, which mostly has the effect of triggering the wind down of that scheme. So there currently exists no timeline. So the fears that if employers see this legislation or other legislation gathering speed, that it will hurry the closure down of those schemes. They can already do that. This is the current legislation gap that exists. So we think that timelines are really important, that sponsoring employers are required in a matter of time to come up with a plan to engage. There's room for negotiation of what those timelines should be, but the inclusion of timelines is something we do support.
Thank you. Mr. Hannigan.
No, I'm sorry, Chair. Ultimately, I mean, in terms of, you know, looking at employers and the provision of DB schemes, and Deputy O'Dea is correct in the sense that there can be an incentive never to lose the opportunity of some crisis. And it doesn't matter how temporary the crisis is, a crisis, generally speaking, will be not necessarily visited upon the shareholders in the company, it will be visited upon the employees in a pension scheme. And any piece of legislation that provides a degree of protection to workers in that circumstances has to be welcomed. I mean, the one thing that a defined benefit scheme does for a worker is that the person is with a degree of certainty. Well, so far as we can have certainty over 30 or 40 years, but with a degree of some certainty, be able to plan for their retirement and to know what benefits they're likely to get when they get to age 65 or whatever the provisions are in the pension scheme. In DC schemes, as we know, the only certainty that they have is what they're putting into it, and they've no idea what the investment people are going to do with the money at the end of the day. So, I mean, defined benefit schemes where they operate, they do need protection, and they do need, I think, particularly a protection where an opportunity arises to take advantage of a crisis, no matter how temporary the crisis is.
Just a few points. I think Dr. Bramberg mentioned the imminence of the total contribution system. I actually raised this in the Dáil the other day on question time, and the Minister told me that it now is envisaged that it won't be introduced until at least the second half of next year. So there's obviously consideration going on about that 40 versus 30 year. As you know, the 40-year period applies to the temporary arrangement for the post-2012 people. But we have strongly argued, and we've made submissions to the Minister about why it should be 30 years for the proper system, which goes into place next year. So hopefully we'll be successful in that. There's also another barrier another issue which has been brought to my attention, which will require a decision by the government, which is that in order to qualify at all for a contributory pension, you must pass the 520 deadline. You must have 520 contributions paid in total. That used to be 260. It was unilaterally increased to 520 in 2012. Why? I don't know what the reasoning was. In relation to what you say about auto-enrolment versus defined benefit pension schemes, I take your point. The government proposals on auto-enrolment says that for companies that have a pension scheme in place, their members naturally they won't be automatically enrolled in. It'll be their own choice, and it certainly there are a number of issues around that. I mean, I take your point about coming up to the level if the benefits are lower, or people losing out if they want to just opt for the. We have made detailed submissions to the government on that as well. They invited us, different political parties, to make submissions. So we've made detailed submissions on that. Just one other thing I wanted to ask you. I take Mr. Hannigan's point, and I mean it's a point that hasn't been, I think, sufficiently emphasised in all this debate. Is the difference, the fundamental difference between defined benefit and defined contribution? I mean, if you meet anybody anybody who's been brought into or paid into a defined contribution scheme, I mean, they were literally wiped out during the recession because these investment managers don't have some sort of hidden wisdom, or they can get it wrong. I mean, the auto-enrolment scheme is going to be a defined contribution scheme. That's the problem. It's going to be a defined contribution scheme. And I was just wondering, and I put it to the Minister, I didn't get any response, but I put it to the Minister, is it possible? I mean, if it's a 662 ultimately payment in 2% by the state, is it possible, I wonder, that some of that could be taken? If say the state contribution, for example, the state pay into that system, that could be sort of used to provide an element of defined benefit, that there be some certainty, that you won't be just hammered because the guys who get the money to invest it make a hames of it or get it wrong or are unlucky or whatever. Is it possible that part of that funding could be used for to give more certainty? Do you have at least a minimum, a floor? I know that the floor is already the contributory old age pension, but I'd like to think there'd be a second floor there, because that's under considerable pressure. It's under considerable pressure. I mean, the chairman can confirm, and Senator Higgins can confirm, we were debating the estimates for social welfare here recently, and if you look at the payments in relation to old age pensions, the £5 a week we gave last year, I think that cost the government about 80 million. But the fact that so many extra people joined the ranks of pensioners cost the government 3 times that much. And that's a trend that's going to continue.
I suppose one thing about the 520 credits, you may, if you haven't already, look at the payment. Well, sorry, I preempted what I was going to say. The 520 contributions that have to be made to qualify even for a reduced pension. In the UK, in recent years, they have removed it that they are required to be paid contributions, that they can be a mixture of paid or credited or all credited, and we think that's a good move. If the 520 is going to remain, they're not going to return to 260. In fact, it may be more beneficial to individuals and the type of people, mostly women caring in the home, the mixture or the allowing credited contributions to be taken into account to make that 520. That was something Congress has requested.
Just to add one single sentence, which is, and of course the 520 is also required if you want to make voluntary contributions.
Oh, I didn't realise that, yeah.
The change when I think Mr. Varadkar was Minister at the time, I had a change on the social welfare bill, so there used to be a 1-year window for to make voluntaries. Now there's a 5-year window, but I didn't succeed in getting them to reduce the threshold. So if you are on 470, it's not only that you don't get into the scheme, but you can't even make voluntary contributions to make it up. So I think that might fit with.
Yeah,
I think
Okay.
that's something that might need to be.
I wasn't aware of that. Our understanding of, you were saying that if a portion of the total auto enrolment contribution could have a DB element of it for the purpose of at least guaranteeing a return. A concern of Congress is that we are requiring workers to more or less requiring them. There is an element of compulsion here. It's a small window if people want to opt out, to put 6% of their pay into a second tier pension. How can we guarantee that they will have some return? Our understanding is that the limited number of schemes that will be introduced, there is going to be some sort of timing factor in that when people reach a certain age, they will automatically go into a low risk plan, and that in itself will guarantee a minimum. I don't think there will be a minimum floor, but the effect of it will that. Ultimately, Congress would argue that the best protection for workers in the auto enrolment is not allowing this to be divvied up by commercial pension providers. Either a public service, a public fund, or Congress are currently looking at an employer-worker master trust, which will be, instead of being profit-driven, will be led with the worker for the worker's benefit, and that's how we're looking to protect the best interests of workers.
Yeah, just briefly, just to follow on from my colleague, I mean, I think one of the emphasis, if you study the Congress submission on auto-enrolment, the emphasis in the submission in terms of the investment and minding of the money is a view on the part of Congress that no matter what our citizens think of the state, they at least believe that if the money is entrusted to the public service, that somebody will look after it for them. Whereas if it's entrusted to simply investment vehicles, the primary motivation of the investment vehicle will be how much money they can make out of it. I mean, even looking at the briefing paper you yourselves had prepared in the context of the legislation, I'm just reading what has to be the most extraordinary statement, that in order to protect people from the potential closure of defined benefit schemes, we should do away with them altogether. To me, it's like a suggestion that we should abolish umbrellas in case you'd open it on a windy day.
Thank you. Okay, before I conclude, because there were remarks made, I suppose, that were a little bit to the side of the bill in terms, and I don't in terms of auto enrolment and total contributions, and they will be separate proceedings of this committee. We expect the Minister to come back. Certainly, going back a number of years ago, the perception would have been the total contributions was going to be over a 30-year cycle because of the remedy the Minister introduced around the 2012 issue. Now a 40-year cycle period is under consideration. But we as a committee expect those debates on both auto-enrolment and total contributions to come back here. We've had the Minister here before. She's made opening statements, so they're not concluded. But before I conclude with you today, Dr. Bambrick and Mr. Hannigan, in relation specifically to the bill proposed, are there any elements of the bill proposed by Deputy O'Dea that you have concerns with or that you think should be modified in any way?
Look, I think, Chair, to be honest, in terms of the actual provisions of the bill, or in terms of the provisions of the bill or the proposal as originally published by the government,
well,
I mean,
let me stop you there.
Yeah, okay.
We're not dealing with the government's proposal today. The government's proposal is sort of parked. That's the government's prerogative. This is specifically pre-legislative scrutiny, committee scrutiny around Deputy O'Dea's proposal.
Yeah, okay. I think the observation we have is that, yes, perhaps there could be modifications to Deputy O'Dea's bill to deal with some of the concerns published in the briefing paper, but the absolute principle underpinning Deputy O'Dea's bill is welcomed by Congress, because the principle of the bill is to provide protection to people in defined benefit schemes. Now, to be quite honest, in terms of the mechanics as to whether or not you go into a more detailed piece of legislation or protections over a more detailed time frame, I think the principle that we would wish to see agreed is that the protections need to be put in place.
Dr. Bamber.
I just echo that.
Deputy O'Dea, any further comments?
Yeah, if you have any, I mean, I will be obviously amending and redrafting the bill as, when the pre-leg discussions finish, and if Congress have any specific suggestions for amendments or anything like that, feel free to send them on either to myself or the chairman.
Like this, despite it being private members, legislation goes through the same process, so there will be committee amendments and report and final stage amendments. So the very specific proposal made by Deputy O'Dea is if there are elements of the bill that you have significant concerns with and you would like to, whether it's in terms of timelines or so forth, please make those known to the committee. While the bill is published at this stage, it goes through the normal stages, so committee stage, and amendments are possible. And as you heard, Deputy O'Dea is up.
Stage.
And as you heard, Deputy O'Dea is open to those amendments. So we appreciate your attendance today. But separate to that, you may have a look at it, and if there's anything further you want to come back to us with, please do. Colleague, no further points. So Dr. Bambrick and Mr. Hannigan, thank you very much for your attendance today. We're sincere about that offer. If there's anything you think should be changed, please correspond with us. Colleagues, thank you for your attendance, and we will now stand adjourned until 10 a.m. on the Thursday, the 9th of May. Thank you.